Because faculty are the institution themselves, they should have a significant role in the governance of their academic institution. Tenured faculty is a presumption of competence and continuing service that can be overcome only if specified conditions are met. The 1940 Statement of Principles on Academic Freedom and Tenure, otherwise known as the 1940 Statement, along with other AAUP policy documents, notably the Recommended Institutional Regulations, RIR, speak to the termination of tenured applicants. Essentially, faculty with tenure should have permanent employment unless there is either adequate cause or the institution is experiencing financial stress or exigency. Faculty with term contracts are those faculty who have contracts lasting a semester or 1 year. These members can include those on probation for tenure, visiting faculty, and strictly temporary or part-time instructors. The legal employment relationship between faculty and administrators is bound by constitutional law, contractual obligations, state law, and academic custom and usage. Dismissal for cause of faculty. One of the most contentious issues in higher education involves efforts to terminate the tenured appointments of faculty members and term appointments of faculty members before their expiration. What is just cause? Adequate cause has been defined as a basis on which a faculty member, either with academic tenure or during a term appointment, may be dismissed. The term refers especially to demonstrated incompetence or dishonesty in teaching or research, to substantial and manifest neglect of duty, and to personal conduct which substantially impairs the individual's fulfillment of his institutional responsibilities. Substantive grounds for dismissal include immoral behavior, neglect of duty, incompetence, and ethical misconduct. There are a couple procedural protections in place for faculty who are undergoing potential dismissal. One is due process under the law. Although this process may vary, most due process procedures include 1. A written notice of the grounds for termination, 2. Disclosure of the evidence supporting termination, 3. A right to confront witnesses, 4. An opportunity to be heard in person and to present witnesses and documentary evidence, 5. A neutral and detached hearing body, and 6. A written statement by the fact finders as to the evidence relied upon. The second protection is academic due process, and the concept of academic due process is a system of procedures designed to produce the best possible judgments in those personnel problems of higher education which may yield a serious adverse decision about a teacher. There are other sanctions that are less than dismissal for cause that are an AAUP policy. Again, there are sanctions less than dismissal for cause. Sometimes decisions are made to sanction them, and they are less than dismissal. Some of those sanctions, as described in case law, include warning or reprimand, public censure, departmental reassignment, actions on salary, denial of salary increase or salary reduction, fines or restitution, suspension, paid or unpaid, as well as immediate suspension, a demotion in rank, modified teaching assignments, class monitoring, and mandatory counseling. This information on how to discipline, terminate, or non-reappoint faculty was taken from UB in 2004, Termination and Discipline. Here you can see a couple other sources which may provide some useful information as well. This concludes our professional development on faculty evaluation in higher education. Thank you for watching.